Welcome to Tony Martignetti Nonprofit Radio coverage of the National Conference on Philanthropic Planning. We are in San Antonio, Texas, on the Riverwalk in San Antonio. My guest now is William Sammers. He is Vice President of Planned Giving and Endowments with the UJA-Federation of New York in New York City. And his seminar topic is Bequests, Tricks of the Trade. Bill, welcome to the show.
Thank you.
It's a pleasure to have you.
Nice to be here.
Part of what you're talking about is making bequests irrevocable, which is not the common understanding, I think, of bequests. But before we get to that, why is the topic of bequests in planned giving something of relevance?
Well, bequests make up at major charities about 70% of the planned giving revenue, and at smaller charities closer to 80 or 90%. So while they may not be the most interesting part of being a planned giving professional, they are the key source of revenue for most charities that have a planned giving program.
Yeah, and do we also see that just the aside from the charitable dollars, but the numbers of gifts in a planned giving program are mostly bequests? Do you see that also?
Yes, absolutely. The number of gifts in a planned giving program are directly much more bequests than any other type.
Okay.
Not only that, there's a lot of money out there in bequests. I often use the example of Leona Helmsley, a very wealthy person who gave away $100 to $200 million in her lifetime, which sounds like a significant sum of money.
Right.
But her estate was worth $4 to $5 billion. So even the most wealthy hold on to their sums of money during their lifetime. And so bequests are a big source not only of revenue, but a place as to where you should look for, because people hold on to their money at whatever level. Obviously, those who are not as wealthy will save more of their money, but even the most wealthy don't give a lot away until they die.
And of course, the bequest is an ideal gift for people of modest means, right?
Absolutely. If you that way you know that you're safe and can live the life and take care of your health care and take care of your children if needed, and then make a decision as you close to as you're older of what you want to do and how to make a difference.
Now, at UJA-Federation of New York, do you see that bequests are the way that people of modest means make that gift, the sort of maybe the ultimate gift they would have liked to have done during life but just couldn't afford it?
Yes, I do see that.
Yeah.
Absolutely. There are people who we've had a postman who ended up giving us $3 million.
Right.
There are stories like that, but there are a lot of stories. They could be smaller, but even you get 10, 100,000, whatever it may be, it could be a significant sum for the person who could not make a significant annual gift. But interestingly enough, one of the reasons that I believe most major gift donors don't make these kind of gifts is because they're not asked, and it's not just those who are of modest means who can make bequests, but people of all wealth status.
And this is digressing a little from your topic, but since you brought it up, what are the methods that you like to see for soliciting bequests?
So a lot of people, the easiest thing if someone is experienced is to be just perfectly outright there and say you care so much about your organization, you've been giving during your lifetime, would you consider making a long-term permanent gift, something that will last beyond your life?
Mm-hmm.
Or will you put us in your will more directly?
Yeah.
But many people are uncomfortable doing that. So in my presentation, I had a lot of ideas that you can use to get into the topic. I use examples of people telling a story. So you can, in order to get to that soliciting bequest, you could tell a story of some other donor who did it as a way of leading into the conversation with someone else. Mm. You can use a story about recognition, about ways that they could be recognized. You can talk about tax policy. Right now, with all that's going on in the nonprofit world about tax policy, if you bring up the subject of what do you think about tax changes, what do you think about the estate tax, that sort of gets into the conversation without being so direct. There are a lot of different tricks of the trade, as you might say, in how to do this, and I can go through more whenever you'd like.
Okay, but let's why don't you share another couple of ideas of how to get into it, and then we'll talk about the irrevocability part. Yeah, go ahead.
So I like to talk about the impact that other people's gifts have made and talk about the long-term needs of the organization. So I might say not only a story, but I would talk about some program that we're doing that the donor might care about or some idea, and then say, by the way, did you know that was funded by another bequest or someone else's endowment? So that's a way of really talking about the meaning of your charity, getting into it, and by bringing up how it was funded, you've sort of opened up the subject to the person.
Sure you have. Yep.
Without asking directly, because
Right.
now they're aware that that's a source. A lot of people aren't aware.
But the conversation is certainly going in that direction.
Right, exactly.
Yeah. Okay.
You can. I mean, the key thing is to talk about maybe what kind of family legacy they want to make. How did they learn from about their parents? How did they learn about philanthropy? How did the sort of Barbara Walters style of getting into the emotion of someone and their values and getting them to unveil their emotions? Because by then they may talk about, I would like to pass these values on to my children. I care about philanthropy. I care about, this is why I want to make a difference in life. This is why I want to have a legacy. And that automatically leads into a conversation. Have you thought about doing this as a way of doing that?
Okay. And after someone does this or says they would like to do it, now we get to the topic of irrevocability. So first explain how it is that a will can be irrevocable, because that's not the common understanding of a will.
So most gifts in the nonprofit world that are bequests are revocable. The common understanding of a will up until the day
Okay, so we went to different law schools. So you say revocable, I say revocable.
Okay.
But that doesn't matter. It's tomatoes. That it all means the same thing.
Right.
Go ahead, please.
Yeah. No, absolutely.
Yeah.
So most are revocable, as you might say. That is, until the person dies, they can change it up until the last hour before they pass away, etc. As long as they're competent. And that is the way that most people understand, as you say, the way wills work. But some people, for a purpose, if the charity has some reason to get them to sign, and I'll explain what that means in a minute, will sign a document, a contract, a pledge that is called a testamentary pledge, which makes their agreement to pay irrevocable regardless of what their will says. So even in the case that their will doesn't have the charity in, because they've signed this document, the charity could go to the estate as a creditor of the estate and say, you owe us blank amount of money.
And so that applies not only if the person never included the charity, although they had said they would, but even if they had them in and then took them out of their will?
Correct. Or, and more importantly, it would happen where the will is challenged by heirs, which is often the reason that a will gift to a charity is taken out of the will, because of that will is declared invalid and a prior will is said valid, because the kids, obviously, not to say that kids are selfish, but sometimes they may want the money. By having this contract, the charity would be protected because they could go to the estate and say, I don't care what will you have in effect. Either way, this money is owed to the charity.
Okay, so it's not contingent on the outcome of some will challenge.
Right, exactly.
Right. Okay. Yeah, go ahead.
No.
Okay, so it's a contract. So now, are we talking then about state contract law governing this? So this is going to vary across states? Or
well,
what?
so you it will vary across states, but I would say, almost all states will enforce these agreements. At this point, there's not a state that has not said they're not valid. There has to be something in exchange. As you may remember from law school, there has to be something.
I remember, but a lot of listeners didn't go to law school, so let's talk about the exchange.
So there has to be something.
Now, this is Professor Sammers now. This is contract law, contract law
to make it
year.
simple, the donor would have to get recognition, their name on a building, their name on a scholarship fund, their name on something that they would be getting in exchange for this promised gift.
Okay. So the school is promised, not a school necessarily. Why did I say that? I don't know. The charity is promising something in exchange for the donor's promise to make a payment at their death, that their estate will make a payment at their death.
Absolutely.
Okay.
And the more you can provide some sort of benefit to the donor, that's not financial benefit, because you can't have a tangible financial benefit. But if it's recognition of some sort, the more that anyone is going to enforce this. So certainly a name on a chair, if it was that, a name on the program, if you were a charity and you ran programs and you put the name of the donor on that would be considered substantial enough for the states to enforce this gift
Okay.
requirement.
And that promise, of course, the charity is not complying with until the death of the donor.
No,
Is that right? Or-
the charity sometimes, and often the reason that you will get someone to sign one of these agreements
Okay.
is that they will provide the recognition during the donor's lifetime. It serves two purposes. The donor gets obviously to see their name in lights, but not everyone cares about that. But they get to see the actual effect of their charitable gift in the sense of that program is in their name. So even though the gift's not coming in, the reason the donor will sign it is because they want to lock in that kind of recognition.
So we have a program that's not funded.
That presumably the charity is funding anyway, or has some other source of funding. For instance, at a university, and not only talk about a university,
Yeah,
could be any other kind of situation. It could be a
Could be
community
UJA-Federation of
could
New
be
York.
UJA-Federation of New York, right? We fund a lot of things from donors' dollars that don't have recognition on them. So we make grants for programs that don't have a name attached. You could put a donor's name on that program because you have other dollars to support it right now in the exchange for the fact that you're going to get a larger gift later on.
Okay. There might also be the possibility of the donor funding it during their lifetime. So they made a promise to do it at death, but maybe this opens a conversation for funding during lifetime?
Absolutely. So what I like to call about alternative bequests, the problem with bequests is they're great, but they don't happen now. So it could be a long time for the money to come in for a charity, and you need money now to operate programs or to operate someone's salary, whatever it might be, to make a difference in the world. So donors can do a number of alternatives that give some money now and some money later. One of the ideas that I've sort of come up with is which has started to become popular in the nonprofit world, is what is known as a virtual endowment.
Okay, let's define that.
Let's make it clear.
Yeah.
For an endowment in general, because some people may not understand it, is where a donor leaves a bequest or an outright gift of a pool of money, and the charity only uses the interest on that. So the principal stays and grows for the long haul in perpetuity, forever. But each year the charity uses a percentage to fund the program.
Okay.
If the charity were to get a current gift of whatever, maybe we'll use 100,000, make it meaningful for most charities, because that's yes, it's a big gift, but if you're talking about a long-time gift, that's a significant gift. Not everyone can afford 100,000, not everyone can afford $1 million, not everyone can afford 10,000, whatever it may be. Not everyone can afford the price of endowing some sort of program. But they can't afford it at death. As I talked about earlier, people save their money till death. So they know at the time of death they'll be able to make that gift of 100,000.
Mm-hmm.
But they could afford, if you were to get as a charity that 100,000, you would invest it and only spend, let's say, 5%. That's what most charities use. So you'd be spending $5,000 a year on that 100,000, and the 100,000 would continue every year, and the charity would continue to spend 5,000 to support a scholarship student.
And then that 100,000 is earning interest also, and hopefully it earns 5%. Some years it will earn more, some years it will earn less, but roughly 5%, and those are evaluated annually, maybe. Okay.
So the charity would like the 100,000, but it can't get it. Okay, because the donor can't give that. But the donor can afford to give $5,000 every year during their lifetime, plus $100,000 at death. Why they call that a virtual endowment, it puts the charity in the same place that they would have been if they'd gotten the $100,000 gift immediately, because they're going to get $5,000 every year till the donor dies, plus the $100,000 that they would have ended up with anyway from the original endowment gift. And this allows the charity to fund the program, to honor the donor during their lifetime. They get to see the philanthropic effect of their dollars, and they get to know that it will continue on in perpetuity.
Right, and the charity's getting, as you said, I'm just repeating because I think it's an important point, the charity's getting exactly what it would have gotten because it would have spent 5% of $100,000, it's getting $5,000 outright in a pledge.
Correct, and they call it virtual because it's as if you had the endowment.
And you find these conversations flow from the conversation around a bequest?
Yes, I often find the conversations flow around finding what the donor is interested and then talking about how they could possibly fund it. So you're not going to get someone to sign an irrevocable agreement for nothing. there has to be something they're interested, something they care about, some specific project. It would be very hard for them. Not too many people will sign one of these for general funds for the organization because they'll leave it in their will and that'll be fine. But if there's something the donor has a passion for, a connection with, they could, I get into the conversation and I say, I know this is maybe more than you can afford, but here's a way of funding it. You can give us a small amount every year, and when you die, when you pass away, however you want to phrase it, in your estate plans, you can provide for the lump sum that I know will be much easier for you to give.
We talked a little about state law, the requirement for the exchange. Is there anything else that these agreements need to have in them?
Yeah, there are a number of things that I talk about that I think should be included. I also number one, like to put a story in the first preamble about the charitable gift. So it's not only an agreement, but that the donor understands the meaning behind why they're making it. So when they get the contract, they don't look at it only as a contract, but also a story behind their gift. I think it makes it more of a positive experience for the donor instead of a negotiation, which you're trying to stay not so much involved with.
Yeah.
Two, you have to obviously make it binding upon the estate. I mean, that's critical, that regardless of the will, et cetera, that it has that. A sort of thing that I often put in is that, and this is just legal language, that anyone can sign any copy of it. In other words, there's a legal term for it, but you don't need to get the legal term. But often at times you're trying to get these documents in by the end of the year, by the end of a charity's fiscal year. So people put in clauses that allow copy A to be signed in, especially if there's children involved or other people or spouses.
This is when there's multiple parties signing.
Yes, exactly.
Yeah. Okay.
It enables it, make it easier.
So what you mean is if there's 5 people signing, each could sign a different copy.
Right.
And they all can be construed as one. Is that right?
Right, absolutely.
Okay.
I have a list of items that are helpful. The key thing is to name which it is. Who is the donor, actually? Who's the state? Is it a foundation that's making the commitment? Is it a donor-advised fund? Is it the donor themselves? Where's the source of the giving? There are a lot of tax implications if it's done as the wrong entity. So the entity must be clear as to who's making the commitment. That is very clear. I know this may sound strange, but I actually get into the size of the recognition or what specific recognition might be.
Okay.
I've had donors who thought they were getting X and are getting Y, and I think it's important to outline specifically what the charity is going to do for the donor and what the expectations are. That also will protect with the family down the road to make sure that they feel happy about the gift, and it's more of a positive experience than them wanting to challenge the gift.
So you include a lot of detail about what the recognition is, what this promise from the charity is in exchange for the donor's promise. A lot of detail.
Right, a lot of detail. I put in what kind of publicity. Are they going to be on nonprofit radio? Or are they going to be on some?
Oh, wow, that's $1 million gift at least. We don't go anywhere below $1 million.
Yeah, but what specifically is the kind of publicity that they'll get for this gift? I include information about that, and I also include details about the project. Meaning, if a donor was actually sent a proposal or was spoken to about the project by maybe a director of the program, I like to include what it is. The most important clause, though, that I think is necessary in any of these agreements is a clause that says, what happens if this program no longer can be run for whatever purpose? Diseases no longer affect, the camp is closed, the college is different, whatever your organization is doing. We're not running that kind of psychological care anymore. Whatever you're doing, how can the money be used otherwise to still support what the donor was interested in and what the charity is doing? And you need to come to some sort of clause agreement about that satisfies both parties, because the worst and most difficult situation is when one has to go to court over this down the road, especially if we're talking about a perpetual gift. It's one thing if you're talking about a gift that's going to come to you as soon as the donor passes away, which usually is not so long after. I mean, it may be 10, 15 years, but it's not 100 years after the donor signs one of these agreements. But if it's going to be for a long-term purpose, I would definitely include that.
Okay. And it sounds like the charity needs to have this drafted by an attorney. Let me ask, is it the charity drafting it for the donor and the donor's attorney's review, or do we let the donor's attorney draft it for the charity's review?
My preference, if your charity is sophisticated enough or has an outside person who can do this, there are plenty of outside lawyers who offer these services, especially in the planned giving community, to have the charity draft it.
Right. We'd rather be working with our language
right.
being reviewed by someone else than us
But-
reviewing theirs.
And also from a donor's perspective, they would prefer that as well for two reasons. One is they may not sign this. So the last thing they want to do is go out to hire an attorney for an agreement that may not be agreed to. And a lot of donors, even if they were willing to sign, don't want to spend the money for whatever reason. They don't want to spend their money to support charity on their attorneys. So they'd prefer that you do the drafting as the organization and then let their attorney review it.
The charity may have a resource on their board.
They may have in-house resources are a great thing. It could be someone on your board, someone in your community. It could be in many charities you have lawyers who are somewhat involved. You can use those. People may offer these services as a volunteer, and they may offer their services as a legally paid representative. But if you have someone in-house who can do it, whether it's on your staff or on your board or somewhere involved in your organization, I recommend you use that source as much as possible.
Important to point out that this is a contract, so both sides should be represented by an attorney.
Absolutely. In this case, I would, if you ever are afraid that there may be a challenge, and in most cases there might be because the family may challenge it, I would encourage you to have the donor have their own attorney. Otherwise, the whole gift vehicle may be challenged completely.
Yeah. Bill, we have just about another minute or so. Is there another alternative will arrangement that you want to just expose us to?
Yeah, sure. I mean, I like to involve the family, so I often say to donors, create a bequest which your family could participate in, so that the next generation can also participate in this gift. So in the bequest that says, I will create this fund, and I will allow for others to give to it. And then people can make gifts in recognition of you when you pass away, friends and family members, in honor of a birthday or someone's older, an 80th birthday, whatever it might be. It could be younger, and also that the next generation, as in the grandchildren, will give a little bit, even if it's $500 or $100, that they're participating in this charitable gift together as a family. There'll be more positive feelings about it. You'll be able to transplant your values to your grandchildren and your children, and everyone will feel good about the charitable gift instead of feeling like money was taken away from the family. It's a family gift together to support something that charity cares about.
That's a great place to end, thinking about the next generation and maybe the generation after. I have been with Bill Sammers. He's the Vice President of Planned Giving and Endowments at UJA-Federation of New York in New York City. We've been talking about bequests, tricks of the trade. Bill, I want to thank you very much for being a guest. It's a pleasure.
You're welcome. Thanks very much.
This is Tony Martignetti, Nonprofit Radio coverage of the National Conference on Philanthropic Planning in San Antonio.